In mediation, what we do is we put the parties in charge. You and I have a dispute. I think, knowing you and knowing me, we'd like to be part of the solution. And that's what mediation lets the parties do. But more importantly, it lets both sides get some certainty in a situation where uncertainty rules the roost.
Hello, everyone, and welcome to Practical Law, Episode 2. I'm Christopher Pracht, your host. As you all know, Practical Law is a podcast that is designed for practitioners and people. It offers real-world advice from experts in a myriad of fields, and we're very happy today to have Eric Englebardt with us. Eric is one of the top mediators in the state of South Carolina. He's also been a practicing attorney for almost 40 years, and so we're very happy to have him here today. Welcome, Eric.
40 years, that makes me feel really old.
Something, man.
Thanks for having me, Chris.
So, one of the things I want to share with our audience here is your background. And you are obviously one of the best mediators in South Carolina. But tell us a little bit about how you found yourself where you are today.
Well, first of all, thank you for that. I'm not sure how deserved it is, but I appreciate it. I came to South Carolina out of law school in 1989 and started practicing law here in Greenville. I spent first 26 years of my practice was focused mostly on being an insurance defense lawyer, corporate defense lawyer, handling cases against guys like you who fight on the plaintiff side. But my practice started shifting toward early in the 21st century. I went from being a defense lawyer who did a little bit of mediation to being a mediator who still dabbled in defense work. And then about 8 years ago, I totally switched sides. And now when I'm not mediating, I'm handling cases like you do. But I got interested in mediation toward the late 90s as it started sort of snowballing in from something nobody had heard of into something that now dominates our practice. Chief Justice Littlejohn, who was the former Chief Justice of the South Carolina Supreme Court, after he retired, it became his baby. He wanted to push mediation in South Carolina. He started mediating cases. It used to be hilarious. You'd mediate a case with him and he would tell you, this is the 98th case I've mediated and 97 of them have all settled. And I would think, that's the 5th time you've said that to me, Justice Littlejohn. But he was very good and mediation really did work. I don't know if it worked in those percentages, but it did work to get cases settled. And I sort of felt like my personality it meshed well with that practice. Sure. And so I went and got certified and started mediating cases in right around 2000. And now it's what I do about 95% of the time.
And at some point along that timeline, Eric, it became mandatory, right?
It started really more in the federal courts in South Carolina, where in every scheduling order, still the same thing is there. There's a footnote on every scheduling order in federal court in South Carolina that requires mediation and talks about who has to be there and that kind of thing. As that became normal in federal court, people started using it voluntarily in civil court. And then in 2006, the South Carolina Supreme Court issued an order that made it mandatory for all civil cases in circuit court.
Gotcha. So let's take a step back for the average citizen that's out there that, most folks don't want to be involved in a lawsuit at all in their life, right? And, maybe they're involved in one or two throughout their entire life. Just kind of share with, the person that doesn't know what we're talking about. What is mediation? What does it try to accomplish?
All right. So the key thing, I think, to mediation is it puts the control in the hands of the right people. And let me do it this way by sort of juxtaposing what happens in court versus what happens in a mediation. Yeah. In court, you have no control. The judge is going to be in charge of all the legal issues. The judge is going to say when you have to be there, when you get to go to the bathroom, when you get to take a lunch break. And more importantly, we'll be deciding the legal issues in the case, ruling on motions, deciding what evidence comes in, all that kind of stuff. And then you have a jury. Most of the time, who would be deciding the factual issues on the case. And lawyers like, when I was a defense lawyer, you and I handle cases against each other, you'd be trying to persuade the judge and jury to make the decisions in your favor on the legal and factual issues, and I'd be doing the opposite. None of that happens in mediation. Right. In mediation, what we do is we put the parties in charge. If you and I have a dispute, I think, knowing you and knowing me, we'd like to be part of the solution. And that's what mediation lets the parties do. They get to control the solution on their own. Doesn't mean that judge and jury aren't important, because ultimately what you're going to be talking about in mediation is what do we think happens in the courtroom. But more importantly, it lets both sides get some certainty in a situation where uncertainty rules the roost. Every decision the judge makes can affect the outcome because of how the jury is going to look at the facts.
Sure.
And so avoiding that, getting certainty, is to me a much better way of doing things.
So in a mediation, so you've got, let's just say, two parties. They've got a dispute. Let's say it's a car wreck case, right? They come to you for mediation. You're not a judge. You're not going to decide the case, right?
Yeah, I have no power. Yeah, and that's, and I know I've mediated for you before. The first thing I always say in a mediation is thank you. I always thank the lawyers for asking me to help. Sure. And I put it that way on purpose because I want the parties to recognize my role is as a helper. I'm not there as a judge. I'm not there as an arbitrator. I'm not making decisions for them. They're the decision makers. My job is to help them be as objective as they can be. People ask me, Eric, your mediation, what is your goal? And they just assume I'm going to say, well, my goal is to get the case settled.
Right.
And I honestly, I want to get the case settled. And that's because having tried 100 or so jury trials, and seeing clients who I knew were right lose, or clients that I maybe thought weren't right win. To me, avoiding that is a really good thing.
Sure.
But that's not my goal. My goal is that the end of the mediation, when the parties are making their decision, their last decision, are we going to settle this case or are we going to move forward and go to court? I want to know they're doing it with their eyes wide open. I want to make sure they're being objective. Yeah. And objectivity in a lawsuit is difficult. Okay, you know that. Your clients are emotionally vested in their position. Yeah. The defense side is the insurance adjuster, or if somebody's been sued personally, they're emotionally invested in their decision. If you're a plaintiff and you believe you've been hurt and the defense lawyer is saying, we don't think that you can prove your case, that's a hard thing to hear. Right. And so separating that emotion from the decision-making process is a huge part of what I do as a mediator.
I think that's a great point, because I think what happens to me oftentimes in mediation, particularly when I mediate with you, because you're a good mediator, is even me as the lawyer, I lose a little bit of objectivity, right? Because I've worked the case up and I'm always looking at it primarily from the perspective of my client and, advocating for them. And then we get to mediation, and usually, even though I've tried to argue both sides to the client before we get there, I would say 95% of the time, particularly if it's a good mediator, they point things out that I haven't mentioned. And, that can kind of be a little bit of a moment of truth for the client when they say, oh, I haven't heard that yet. And so I always think kind of that objectivity point you're making, that mediation is so valuable because you get fresh eyes on a case. And so tell me about how you handle that in a mediation. I mean, when you're talking to parties, how do you try to bring them back and pull them away from their subjectivity and make an objective decision?
One of the things that I always say in my opening statement is that I warn everybody. I'm going to play devil's advocate. Okay, what I'm trying to help everybody do is put the pros on one side of the page and the cons on the other as they're evaluating the case, because ultimately, that's what mediation is. It's an evaluation process, but it's hard to evaluate if you're being emotional and you're not just focusing on facts. So what I warn them that I often say, I know it's a good mediation when everybody's gotten mad at me at some point, because I am going to question your positions. I am going to make you really try to examine the pros and the cons of your case, and people don't like to do that. But in addition to me being the devil's advocate, what I also tell them is that I want you to get in the jury box. The way mediation works is, most of the time, what I really want the parties to do, or the lawyers to do, is talk to the other side. You're going to go first as the plaintiff. I'm going to say, Chris, why don't you tell us a little bit about your position? And I want you to talk honestly and directly to the insurance adjuster or to the party on the other side, depending on the situation, and tell them about your case. That sounds silly because you've been working on this case for a while. Most of the time, the insurance adjuster's not heard from you directly. The party's not heard from you directly. They haven't had a chance to assess how good you are and the way you're going to present things. And I want that adjuster to hear that from the jury box. Same thing's true in reverse. I want the defense lawyer to talk to your client. I want your client to understand where they're coming from. There's a lot of massaging that has to go on how you present it, because one of the things that people worry about is that an opening statement is going to go down the road toward pushing the parties apart because you're telling people things they don't like. I try to sort of massage that from the start by making sure they know that's coming. But it's important for them to do that. One of the things I always say is, don't cheerlead when your lawyer's talking. And I usually say, don't throw things across the table when the lawyer on the other side is saying something you don't like. Because and here's why I think it's so important. In court, they're going to hear everything. More importantly, the jury and the judge are going to hear both sides before decisions are made. And so it makes sense for the parties to hear each other out before decisions are made. Again, it's hard. And I spend a lot of time, I'm always taking notes during a mediation, but I spend a lot of my time as the neutral, watching body language, watching reactions, trying to understand, what are the points that people are uncomfortable about or that they want to respond to. People are always going to want to jump in and respond to, that's not right.
Oh, yeah.
Doesn't matter. They don't get to do that in court, and they don't get to do it in mediation.
Right.
I'll let them tell me once we split up and we go
Sure.
into a caucus, one side or the other, just with me. I want them to react. But that's when they get mad at me, because then I said, well, what about this? And what about that? And make sure that they understand that there are two sides. If everybody agreed on the facts,
we wouldn't be there.
You wouldn't be there.
Absolutely.
So it's important for the parties to recognize each side of the case.
So opening statements, and just to kind of share with folks, usually the first thing that happens is mediation is we'll all be in a conference room or on Zoom in a single room, and each side will present a brief presentation on their case. Tell me you've mediated thousands of cases now, probably, right? What do you find is the most effective way to handle that opening segment as either a defense lawyer or a plaintiff's lawyer?
That's a great question, Chris. It's an art. It really is. I watch, one of the interesting parts about being a mediator and being a neutral in these situations is I get to observe lawyers.
Right.
And I see good lawyers and I see horrible lawyers.
Sure.
There are lawyers who cannot check their own egos. They want to win a mediation, and you can't win a mediation. All you can do is settle or not settle. You're not going to get over on somebody. The key is to be able to call a spade without attacking. I can say to you, you lied at your deposition. You misstated the facts about about your prior medical conditions. You were trying to fool us. Well, what are you going to do? You're going to get defensive if I say that to you.
No, I didn't.
Right.
That's not true.
But if I say to you as the plaintiff, if I'm the defense lawyer, if I say to you, listen, I don't think you misrepresent anything on purpose, but I want you to understand what the jury's going to hear. The jury's going to hear that I asked you at your deposition, had you ever had neck pain before this accident or ever been to a doctor for neck pain before this accident? And you said no. I think you forgot. But I want you to know the medical records show that 6 months before this accident, you were at the doctor's office complaining about neck pain. My job is going to be to make sure the jury understands that happened and that you didn't tell me the truth about that. Now, if you're sitting on the jury, how might you think about that?
Sure.
And if I say that to you, now you're like, oh, wow, I didn't realize that.
It could be a problem.
And now I'm going to have to explain. And you and I both know when we're explaining as lawyers, we're losing. Right. So we want things to be clear and cohesive. Telling the other side a bad fact in a way that makes them question their position but not get defensive, that's the key to a good opening statement.
I love that. Let me add, one thing I struggle with as a lawyer with openings, right, is how much. And what I mean is, obviously I want to share all the relevant facts, but do you think a long, in-depth opening statement that hits every single point is preferable to maybe a shorter just summary and, hey, let's just get to work? Where do you fall on that?
I don't know that there's an easy answer to that. One of the things as a mediator I always have to try to overcome is people who want to hold all their cards close to their chest and don't want to share anything. Well, then they're going to usually end up in court. You got to decide, do you want to settle the case or not? And sometimes the way to settle the case is to, like I just said, put some of those cards on the table and say, here's a problem you got to overcome. Getting people to do that, that's one of those things as a mediator that you spend a lot of time doing, is saying, listen, don't you think I should share that information? Let them consider that, and it might change their position. That's a hard thing and it just depends on the lawyer. But let me sort of circle back to something else you asked. It's becoming more and more normal for lawyers to say, I don't want to do I don't do opening statements.
Right.
Because I think it just pushes the parties apart. Well, I just told you,
why you
I
disagree with that.
But the other part of that is that your client gets to see you in action. Yeah. And they get to see that you know your case, that you're passionate about their positions, and that you're fighting for them. If you don't do that, they might be wondering, why am I paying this guy or this woman
100% agree.
A huge percentage of whatever I'm getting? And so it's a lost opportunity to show your client your value to them.
That's a different answer than I thought you'd give, but I think it's a great answer. And when I'm working with my younger lawyers and the associates who work with me, I always say, if you're handling a case and you have maybe a couple phone calls with the client, you've looked over it, and the next time you talk to them, whether it be at a mediation or anything else, is you trying to get them to settle, they're going to be like, what the hell, man? I've talked to you twice and now you're telling me to settle my case. Like, I think that is so critical that they see you in action. They see you advocating for them, because it builds trust. And they say, hey, this lawyer is for me. And then it makes it easier when you come around and say, hey, this is the reasonable value of your case. You need to think about settling it.
Well, it's always cost-benefit analysis. What do we think will happen in court? What's it going to cost us to get there? And then the most important thing is, what is the net to you? Right. And if I tell my client, when I'm a plaintiff's lawyer, if I tell my client, listen, it's going to cost us $20,000 to pay our experts, they're offering you $40,000 today. So, and don't forget, I get my share of whatever additional money comes in. So it's going to take $65,000 in court to put the same thing that $40,000 puts in your pocket today. And there's risk we won't do that. Sure. Well, then when you do, that's an easy cost benefit analysis. Of course, you settle for the $40,000 in that situation. The problem, obviously, is their expectation was, I'm going to get $65,000. Well, they were never going to get $65,000.
It was in the card.
Right. Well, because of the cost and because of the attorney's fees. Getting them to focus on the net, that's another one of those things I point out early on in the mediation as a mediator, is that's what we're talking about. What is the best net result for both sides? When both sides focus on what they think will happen, what are the risks that it doesn't happen, and what are the costs to get there? When both sides do that math, sometimes they're not that far apart. Right. They might have come into the mediation where there was a pre-suit demand of 150 and a pre-suit offer of 10, and they thought, we're never going to get this settled. But then once they start working on the case, realize that their pre-suit ideas might be wrong, and they got to spend a bunch of money to get there, they're really not that far apart. And that's a lot of what I do is pointing out, listen, y'all aren't as far apart as you think you are.
Right, yeah. And it's all... Steve Krause, Steve, he said something to me that I thought was really, and he was mediating a case, and this is when he told me this. And he said, the best defense lawyers do this, Chris. He said, they take the monkey off their back and they put it on your back. And I was like, well, what do you mean by that? And he said, well, if you've got a case that's worth $10,000 and I'm a defense lawyer and offer you $1,000, well, you just say no, But what if I, as a defense lawyer, offer you $8,100? Then you got to get into that cost benefit analysis, and they've put the monkey on your back.
You got to find the sweet spot.
You got to find the sweet spot, right? And so, I guess I'm say that to lead into this question: what do the best defense lawyers do in a mediation setting to advance their client's interests? What are the best practices you see?
My wife, who, as you know, is a United States bankruptcy judge, she one of the things I've heard her say many times is that sort of her mantra on the bench is, I want to be the most reasonable person in the room. And I think as a defense lawyer, I took that to heart too. I always tried to be reasonable and respectful I used to teach a lot of CLEs on mediations, and those were like respect and reasonableness are two of the main words I would use in those talks, because talking to somebody in a respectful, reasonable way and just reasoning with them, that's what good defense lawyers do. Getting somebody to question their positions without attacking. If you go on the attack, then yeah, those ideas about, I don't want to do opening statement is going to push people apart. People who say that, it's themselves that are the problem.
The worst offenders, right?
The reason that when you do an opening statement and it doesn't get the case settled is because you're not doing a good opening statement. It's not because of the opening statement itself.
I got you. Yeah.
And that drives me crazy when people say that.
That's a great point. It's the execution, not the process, right?
And just to take it to the next step, because I would assume your follow-up question would be about plaintiff's lawyers.
Yeah, it is.
The key to me is preparation. Be prepared yourself, and that means don't let the defense lawyer pointing out that inconsistency in the person's medical record be the first time they hear it. You want your client to know what's coming so they're prepared for it. And you need to be prepared to respond and say, if you know there's a bad fact, you want to talk about it in your opening statement and let the jury hear it from you before they hear it from the other side.
Certainly.
And the same thing's true in mediation. If you can take the wind out of the defense lawyer's sails in your opening statement of saying, I know you're going to talk about this, here's our response to it right off the bat. That's a key factor for a plaintiff's lawyer. But the biggest obstacle to settlement is expectations, unreasonable expectations. And you're going to have clients with unreasonable expectations. It happens all the time. And I think, I don't know why, but I think sort of people come to me all the time with cases where they know they've got client issues.
I know.
But you're really good when you know that's coming to give me a call ahead of time as your mediator and say, hey, I want you to know that this is what we're dealing with. So preparing yourself, but preparing the mediator for the issues that you know are coming, that's key. Making sure the right people are there. For instance, a quick story from yesterday.
Sure.
Yesterday, the defendant was a partnership of two brothers, and one of them couldn't be there. Even before we started, the brother who was there was getting to his brother on the phone and talking to him about what they'd be willing to do. Well, I knew what they were going to be willing to do was going to have to change during the course of the day.
Sure.
And so I talked to that lawyer and I said, we got to get the other brother on the phone, on Zoom or with us.
Participate.
If he's if the biggest obstacle to me is a party who's influencing the process who's not there. And so getting them there is important. And you as a plaintiff's lawyer need to know who that is. It's even more true on the other side sometimes, making sure that the actual decision maker is involved. I mediated a case for this lawyer in Spartanburg. It was a weird case. It was a employment case that also had a little bit of med mal in it because somebody had gotten sent to the company doctor and the doctor had messed things up. And she said they had sued the tortfeasor and the company doctor. So you had two defense lawyers there. We spent all day negotiating. In fact, she told me before the case started, if she could get $65,000, that would be a great number.
Sure.
So we negotiate all day, and lo and behold, we get them up to $85,000, and she's ecstatic.
Yeah.
And her client says, that's fine. I would take 85. So I go into the defense room, said, if y'all do the 85, they'll settle the case. Well, employment cases, for some reason, the lawyers really like to get a release signed at the mediation. Most of the time, we sign what we call a memorandum of agreement, and then the lawyers do a more formal agreement later on. But employment mediations, for some reason, the lawyers like to get the agreement signed. But the two defense lawyers got into an argument about language in that release, and it took them about an hour and a half to put that document together. Well, I finally got it. I walked back in the plaintiff's room, and I said, and the plaintiff wasn't in the room. And I said to his lawyer, where is he? And she said, he's in the parking lot talking to his wife on the phone. And I went, this is not good. So I walked out into my parking lot and motioned him to come inside. He comes inside and says, my wife says, if I take $85,000, I can't come home. And this mediation had gone on like 7 or 8 hours.
Right, yeah.
And I said, well, what do you mean? This case is worth $150,000 to her. She's telling me not to take 85. I said, well, she hadn't heard anything we've been talking about all day.
Right.
I said, get her on the phone. So we got her on the phone, and I spent an hour with her on the phone going through the things we'd done in the day and why the case wasn't, what the issues were in the case that I don't care what you tell me, he can't come home if he takes $85,000. So case
Did not settle.
and impassed.
Wow.
2 months later, I get a call from the plaintiff's lawyer. Guess what happened? I said, you lost. And she said, yeah, we lost. We got nothing.
Got zero.
Zero.
Wow.
So that's a case where if his wife had been in the room, I believe if she'd listened to everything all day and I'd had the opportunity to talk to her all day, it would have settled for the $85,000. And they got nothing because the wrong person or the right person wasn't there.
You know, going back to what you said about, and this is my favorite part about mediation too, I think we share this opinion that the parties are in control, right? Tell me if you agree with this statement. This is kind of what I'm saying. I think that these big verdicts you see and the defense verdicts you see oftentimes come from a situation where one party is not being reasonable. And that's why the case got tried in the first place, right? Either the defense has a case that's maybe worth $1 million and they're offering 200, or the reverse, right? And the plaintiff's got a case that's worth 200, or like your example yesterday. Do you see that? Do you think that that's what drives some of these extreme results? Is just people taking unreasonable positions?
Yeah, I mean, I think it's one side or the other is being unreasonable or unwilling to recognize the bad parts of their case. Sometimes they're just outliers. I mean, occasionally you just get a jury that is rogue one way or the other. And we could do a whole podcast on why do some counties look at cases differently than other counties. But honestly, sometimes, Chris, cases just need to be tried. I mean, there are reasonable people can disagree.
Sure.
And sometimes cases impasse and end up in court because there's just a disagreement. Doesn't mean anybody's being a bad actor.
Right.
Again, juries do it. If you talk to jurors after a case is over, you got 12 people in there and you might have 12 different opinions. Sure. And eventually they come to a resolution.
Right.
But they don't all agree right off at the bat. So sometimes the cases, it's okay to try a case. Sometimes it's okay just to disagree, and that's what we have juries for. But I do think, most of the time when cases end up in court, it's because one side or the other is being unreasonable.
Yeah, because I mean that kind of ties into my next question is if you feel like you've got two reasonable parties there that are taking the approach that you've outlined here of evaluating the risk, done the cost benefit analysis, ballpark, what percentage when you have that environment, what percentage of cases settle?
I used to keep stats like Justice Littlejohn, and I haven't kept them in years. But I mean, I think that 75% or so of the cases I mediate settle at mediation, and then the other 25%, most of them settle before trial. Right. I think I have the numbers right. In Greenville County last year, there were more than 7,500 cases filed and 10 civil jury trials.
Isn't that crazy?
It is crazy. And I mean, there were years in the early parts of my practice where I tried 10 cases a year.
Yeah.
And now it's the whole that down across the street from here in the Greenville County Courthouse.
Do you think that has an impact on how we value cases? I mean, meaning, we have less of a sample size, right? Does that put us in the dark more, you think?
I think that could be the case. Yeah, I think there's a lesser sample size, but I do think there's more information out there. It's easier to find out what did happen. There are all sorts of lawyer communication about cases. The cases don't get tried really without us all finding out what happened. I think the real issue is younger lawyers not getting the experience in a courtroom. I think we have a lot less experienced trial lawyers now than we used to. And judges lament that. They're like, mediation's ruined, being a judge because we don't get good lawyers there trying cases anymore. And I'm like, well, what's the goal? Isn't the goal to resolve disputes, whether it's by judge and jury or whether it's by mediation? If we're resolving the disputes more efficiently, isn't that better for everybody?
And undoubtedly, mediation is more efficient than a trial.
And definitely more cost effective.
Oh my God, it's just night and day. All right, well, look, this has been great. I want to wrap up by talking about some current events. So we're going to switch gears outside the mediation realm. I have been, as you know, very involved with this tort reform bill that we have down in Columbia. Wanted to get your thoughts on that and more generally just our judicial system here in South Carolina and, where we see the future from, whether that be the civil justice system in South Carolina and just give me your take on it.
Yeah, we're gonna do this in the quick one.
Yeah, right. I know, right. We could do a whole podcast on
Yeah,
this.
we could definitely do that. I'm very concerned at the tenor of how this whole issue has been put on the table. The idea that trial lawyers somehow are the evil agents of working against justice makes no sense to me. I touched a minute ago, we talked a little bit about the difference in counties. You hear those pushing for tort reform, all they want to focus on are the big results.
Right.
The counties where for whatever reason verdicts are higher. You don't hear them talk about Pickens County or Lexington County or Greenville County, where verdicts are lower.
Sure.
Those who are advocating for change, it's like they get to pick which counties are right and which counties are wrong. Who's to say that the value of a case is right in Pickens but wrong in Allendale?
Right. It's the people's decision.
It's the people's decision.
Right.
And the thing that really bothers me, and I've talked about this before, is that these same people who are saying we can't trust juries to get these civil cases right are perfectly fine with juries deciding the death penalty.
Right.
Juries in Allendale or Pickens.
Right.
They don't differentiate by how they look at that. But when it comes to money,
right.
We can't trust them for that. Yeah. We got to change the law.
Because they're subject to these evil trial lawyers that are pulling the wool over their eyes.
The hypocrisy and the illogic behind that drives me crazy. But what the thing that really bothers me is what they're doing is they're attacking the system. They're attacking judges. They talk, it's not just South Carolina.
Right.
Everybody seems to want to focus on, well, what political party did that judge belong to beforehand, or who appointed that judge? I have been around and known judges and practiced in front of judges now for 36 years. I think the great majority of judges in this state and elsewhere are fighting for justice, and they're trying to do the right thing, and they don't care they take an oath not to care who the litigants are, whether they're rich or poor, whether they're powerful or not, to do justice. And I think the judges do that. And the idea that they're going to constantly let politics get in the way is political in and of itself. The people who promote that have an agenda. And when they don't get their way, instead of looking at is it right or wrong, they attack the system. And we as Americans who have I think the best justice system in the world shouldn't lose sight of that. The idea of due process for everyone in this country is so paramount to what makes America different than every place else. Throwing that out the window is throwing America out the window to me. And so all of this, it seems like, talking about, you asked me about tort reform, I end up talking about due process. It's all related.
It does. It's an attack on the judicial system in general.
Exactly.
It's this attitude that anytime you lose, the system's rigged, right?
That's exactly that is exactly the attitude. You're right.
And Alex Sanders, who you remember was Chief Justice of the Court of Appeals, he had a great sense of humor, and he kind of tongue in cheek told me one time. He said, "Chris, the definition of an activist judge, don't you?" And I said, "No, Judge what?" And he goes, "The one that rules against you."
That's right. I've heard him say that. Yeah. I heard him say that.
I mean, and so that's kind of the idea, right? I mean, it's like we're all going to get results we don't like. We're all going to take L's in the courtroom, and that's just part of being a lawyer or even a litigant. And so, but that doesn't mean you throw the baby out with that.
100%.
Well, Eric, thank you so much for being here today. This has been a great conversation, and we want to have you back on, and I can't wait to mediate with you soon.
Well, I look forward to it too, and I appreciate it very much. Thanks for asking.
Awesome.